sorry, just one moment. I can't get into my Opus 2. I need a memorable word. I don't have anything that's memorable.
I can't help that.
It's just 1, 2, 3, 4, 5, 6.
Sorry?
It's just 1, 2, 3, 4, 5, 6. Yeah. If you can make sure we're all running, it would be great. Thank you.
Where's your issues? Okay.
So, where do I do that one?
You can put it big if you want. You click here.
My lord, you heard a lot from me about Intas period dominance in the sweltering heat of yesterday afternoon. I've more or less reached the end of my submissions on that issue, and I'm going to move on in a moment to issue 1 in the list of issues. Much cooler in this room this morning.
Well, this morning maybe.
Yeah. Issue 1 I'm going to take much more briefly. There were just 2 quick points to finish off on dominance. First, I wanted to pick up the query initially raised by my Lord Justice Zacaroli about whether there is any specific evidence in the decision about the extent to which the skinny label suppliers would have been able to provide the sorts of volumes required by the big pharmacies like Boots and Lloyd's. We've checked that overnight, and so far as we've been able to ascertain, there is no specific evidence in the decision on that point. No evidence to suggest that this was why the big pharmacies paid the bigger bucks. What we do know, and I showed you this yesterday, is that the skinny label suppliers were quickly able to step in and supply around 50% of the market by volume, reflecting essentially those smaller independent pharmacies who were price sensitive and switched therefore to the cheaper product. That switching away, as I said yesterday, happened largely before the Intas period, after which market shares stabilised, as I showed you yesterday.
So that all happened in the period between when they came onto the market in 2015 and the beginning of the Intas period.
I don't have the precise reference to hand, but yes, I think during the first year after entry, around 50% of the market switched away or thereabouts.
Yeah.
And I, of course, showed you table 3.8 in the decision, which showed that the combined demand of the independent pharmacies for hydrocortisone tablets was roughly equivalent to the combined demand of the 2 largest multiples, Boots and Lloyd's.
Yeah.
Secondly, could I just show you one further paragraph from the judgment that is pertinent to the question of dominance during the Intas period, but which I failed to show you during my trawl through the judgment yesterday. It goes directly to Mr. Palmer's complaint that the judge did not give specific consideration to Intas's arguments about its declining prices during the Intas period in the context of dominance. It's at core page 444, paragraph 303, subparagraph 3 of the judgment. So this is in the abuse section of the judgment, which is why I didn't naturally come to it yesterday when I was looking at what the CAT had said about dominance. The CAT is referring here to the argument about prices on the downward slope of the Matterhorn not being abusive. But as you can see from this subparagraph, the CAT here observes that the same point was advanced by the appellants in relation to dominance as well, including specifically in relation to the later phases, and they say specifically those in phases 4 and 5. Phase 5, of course, is the Intas period. And so the CAT clearly did specifically turn its mind to Intas's argument about declining prices in the context of dominance, but decided on the basis of its evaluation of the evidence that these declining prices did not preclude a finding of dominance.
Yeah.
Turning
they
then...
make a specific point at the end of that. The same point can be made in relation to abuse.
Yes, yes.
So, I mean, although in one sense there's force in that, it's the point you made yesterday, there's force in the appellant's complaints that the judgment doesn't sort of, as it were, take dominance and deal with every single dominance point at one and the same time, and then go to abuse and deal with every point one at the same time.
Yes.
This demonstrates that the tribunal was well aware of the overlap, if you like, between the different issues.
Yes.
To which the same arguments would apply.
And of course, when one's thinking about both dominance and abuse of the unfair pricing context, this concept of workable competition is intrinsic to both issues. So there's no surprise that there's some overlap in the consideration in my submission. Unless my lords have any questions on dominance, I'll move to issue 1. This is the issue as to whether the CAT erred in dismissing Intas's argument that Accord UK's prices were not imposed within the meaning of section 18(2)(a) of the 1998 Act. And I can be very brief on this point. In my submission, there is both a factual and a legal answer. As to the factual answer, the factual premise of Intas's argument on issue 1 is that the large pharmacies who continued to pay the large premium for the Actavis product were simply exercising a free choice. And that is simply another manifestation of Intas's challenge to the assured customer base findings. But as I explained yesterday, the CMA found in terms that the large pharmacies had no choice but to purchase from Actavis. And in my submission, that was endorsed in the judgment on a proper and fair reading. That, in my submission, is a complete answer to the imposition argument. The necessary factual premise for the legal argument does not even arise on the CAT's findings, and those were well within its margin of appreciation. And as I understood it, Mr. Palmer accepted in response to a question from my Lord Justice Zacaroli on Tuesday afternoon that if in fact the large pharmacies had no choice, or perceived themselves as having no choice, then his legal argument on imposition would fall away.
Well, there's quite an important elision there. Had no choice, perceived they had no choice, are not quite the same thing.
They're not quite the same thing, but in my submission, in relation to the question of whether there is an effective choice for the purposes of this argument, the really important thing is whether is what the pharmacies perceived, and we've seen how assured the demand was in my submission, how price inelastic they were. So in my submission, on the facts of this case, that is a distinction really without a difference.
There is a nuance to it. I understand the point about the secure customer base. And let's assume they're right in relation to impose upon that group, but not necessarily at the price they wanted to, because the price was coming down and they were therefore responding, albeit at a premium above the skinny rate. They were still imposing, but not without the same degree of power over price.
Yes, I think that's right.
That comes really back to the question of what's meant by dominance. It's an appreciable power over price. It isn't absolute.
No, exactly my point, and that comes actually on to the second point, which is as I put it, the legal answer. Yeah. My Lord, you expressed a concern on Tuesday afternoon that Mr. Palmer's argument, if accepted, might unduly narrow the scope of the unfair pricing abuse. The CMA respectfully shares that concern. If there were a discrete requirement that prices can only be unfair in such circumstances, my submission, that would impose much too high a threshold, because it would involve saying essentially that it is only really monopolists, those who have an entirely captive customer base, who can ever charge unfair prices. But as you just observed, my Lord, and as you also observed on Tuesday, dominance requires only a degree of pricing power and not absolute power over pricing. And that is, you have my point, the CMA's case in relation to Actavis during the Intas period in particular, an appreciable degree of pricing power.
Was it Hoffman and Roche who showed us yesterday? Was it AstraZeneca citing Hoffman and Roche, citing that CMV and other cases? That's always been the case.
Yes.
But it's not absolute. It's appreciable or sufficient degree of power over price.
Yes.
Which doesn't mean to say you can set it at the zenith level, but you can set it at a level which is supra-competitive.
Yes, exactly. I think on the
baseline might be.
Yes, and then obviously I also showed you yesterday United Brands for the basic formulation of dominance and the reference to appreciable extent. Now, if there were a legal requirement of the kind Mr. Palmer seeks to identify, if that is a requirement of the law, then it's very surprising that it's not mentioned anywhere in the half-century's worth of case law on unfair pricing that was considered and synthesised by my Lord Justice Green at paragraph 97 of Plenitoen 1. In my submission, there is no such requirement. And in fact, I will just briefly show you, if you can bear it, United Brands. Authorities Volume 1, Tab 1, page 81. And if we just scroll down to the sidelined text, this is of course the text that started this all off. And if one looks at paragraph 252, the question therefore to be determined is whether the difference between the costs actually incurred and the price actually charged is excessive, lim 1. And if the answer to this question is in the affirmative, to consider whether a price has been imposed which is either unfair in itself or when compared to competing products. So those are the questions to be determined. No suggestion that one needs also separately to ask whether prices have been imposed in the sense for which Mr. Palmer contends. And in fact, the terms of Lim 2, Roman 2 of the United Brands test make clear that this cannot logically be the test. They specifically raise the possibility that prices may be unfair when compared to competing products. Now, the CMA, of course, accepts that where a price has been imposed, whether de jure or de facto on a captive group of customers, this will be a relevant factor going into the mix when one is at the Lim 2 stage and considering the overall question of fairness. One of the key learnings from the Court of Appeal's line of case law and unfair pricing in this sector is that the categories of evidence relevant to fairness are not closed, but that is very different from saying that there is a freestanding legal requirement. Mr. Palmer sought to bolster his case on this point by reference to two authorities, Sinvan and Gutman Boundary Fairs, but in my respectful submission they got him nowhere. In Sinvan, this court did not say anything to suggest that there was any such requirement. Indeed, the Court of Appeal reiterated the earlier analysis of the law on unfair pricing from Benetton 1. Gutman Boundary Fairs, as my Lords, Lord Justice Green and Lord Justice Flaux may remember from the case's trip up to the Court of Appeal at the certification stage, was not a case about United Brands unfair pricing at all. No. It was a case about whether the boundary fares, which were always available to purchase in principle, had been non-transparently obscured from view by the train operators.
It's whether there was double charging.
Exactly so. As this court put it on appeal, the, quote, essential premise of the claim was that this lack of transparency had enabled the operators to double charge customers for their travel. Yeah. And it was in that context that the CAT considered it necessary to ask whether on the evidence the operators' selling systems were so opaque that in practical terms a double charge had been imposed. But in my submission that tells one next to nothing about the law in relation to unfair pricing in the United Brand sense. That simply wasn't an issue in the case.
It wasn't the point. Nobody was saying if there'd been transparency, the fare was an unfair fare.
Exactly so. Exactly so. So my submission there's a separately both a factual and a legal answer to this question, and unless you have any questions, that's all I had to say about issue 1, and I'll at that point hand over to Mr. Holmes.
Good morning, my lords. I'm dealing with issues 2A to 2C. That's the test for unfairness, burden of proof, and economic value. As a structure, I'll start with brief submissions on the case law, and I'll then deal with the appellant's criticisms in turn. In a nutshell, my submission is that the tribunal correctly applied the law and gave adequate reasons in what is a clear-cut case. The incontestable facts speak for themselves. Prices were very substantially above cost plus throughout the infringement period, and that is undisputed. Competition was first delayed by anti-competitive agreements as the Court of Appeal confirmed, preserving an effective monopoly until late 2015. Then, following entry, competition was impaired by the regulatory quirk of the orphan designation. As Mr. Armitage submitted yesterday, that is what the tribunal found in the judgment. Prices for these products have nonetheless eventually dropped to levels at or below cost plus. And that, we say, is a good proxy for the economic value of this old generic product.
It's interesting as well, isn't it, that I think one of the things we were showing yesterday, if you look where it started,
yes,
what the price was when Mr. Patel bought.
Yes.
Indeed,
that's...
It was, what was it, something like 70 pence?
It was.
Increased it to £4.54.
Yes.
And then on it goes, you know.
Yes, and as we'll see, the tribunal attached significance to both bookends. It regarded the temporal comparison of each end to be illuminating. And in my submission, as the CMA found, the price at which Auden McKenzie was prepared to launch the product, relaunch the product, the £4.50 level, is telling. It considered that a viable price. It's a further convergent piece of evidence which matches cost plus, and it matches where we ended up. And so I respectfully agree that that is another significant comparator. And it gives the lie, I should say, to the argument based on economic value, just to anticipate the submission, that this product was rescued, that Auden McKenzie was a white knight. It was prepared to launch the product at £4.50, the cost plus level, and that was clearly a viable price. We've now reached cost plus again, and that is still a viable price. Now, starting then with the law, it really goes beyond sucking eggs for this panel as the authors of the principal Court of Appeal authorities. But I do propose to make a few short points about the three relevant cases on unfair pricing in the pharmaceutical sector. First, phenytoin 1. So that's Authorities Bundle 3, tab 48. Page 1256. And scrolling down the page, paragraph 97 is, of course, where the court gives its summary conclusions from prior case law. And to start with the very basics, just a couple of points to note. First, at Little Roman 1 and Little Roman 2, the basic test is whether the price is unfair. In broad terms, a price is unfair where the dominant firm reaps trading benefits not obtainable under conditions of fair and effective competition, and a price which is excessive because it bears no reasonable relation to the economic value of the product is an example of an unfair price. And those are the elements that this court subsequently uses to explain the meaning of economic value and the evidential proxies that may be used to assess it. Then at Little Roman 5, the two-stage United Brands framework as one legitimate method of approaching the test. First, is the price excessive when compared with cost plus? And second, if so, can it nonetheless be justified as fair in view of other factors? Again, the very basics, but important, as in my submission, this is the approach that the tribunal took. What the appellants characterise as a reversal of the burden of proof is simply the tribunal applying the second stage of this test by looking to see what other factors there are that might justify pricing practices that were clearly excessive. And as I'll show you, the tribunal also found to be anomalous in other respects. Now, of further relevance to the burden of proof issue, the court proceeds to emphasise the important evidential burden that can arise for the undertaking whose pricing is under investigation. And if we could go on to page 1263, paragraph 114, the court makes that point. So this is in the context of the CMA's duty of fair evaluation. In the second line, one sees that the concern had been expressed by the CMA that if the duty imposed was to investigate fully, undertakings could game the system and adopt a strategic approach. But Lord Justice Green notes that this would not be permitted. And the reason is given just below C in the margin. There is an important evidential burden upon the undertaking concerned. And if I could ask you to review, please, quickly the balance of that paragraph. Yes.
Can we just drop down?
Yeah. So it's a simple and quite a basic point.
Well, I was going to say, it's all pretty sort of form book stuff.
Yes.
Isn't it?
There can be an exacting evidential burden on an undertaking where an authority brings forward evidence that could be indicative of an
The legal
infringement.
burden may be on the CMA, but if the reality is what you demonstrate is a price which is way above cost plus,
Yes.
as a starting, then the evidential burden must shift to the undertaking.
Indeed,
Justify that.
yeah,
Put in evidence and justify.
my lord, exactly. That's in my submission all the tribunal was doing.
That's all the cat's done.
Yes. The other relevant passage in this judgment relates to economic value. You've seen this, but it is important in showing the appropriateness of the comparator, the proxy relied on by the tribunal in this case. And it starts on page 1275, paragraph 154. So the concept of economic value isn't defined. In broad terms, economic value is what a consumer is prepared to pay for the good or service in question. But this cannot serve as an adequate definition, since otherwise true value would be defined as anything that an exploitative and abusive dominant undertaking could get away with. So actual willingness to pay, not conclusive. And at the end of the paragraph, the point is made that to overcome this, the United Brands test focuses on a reasonable relationship between price and economic value. And then at paragraph 155, the simple fact that a consumer will or must pay the price that a dominant undertaking demands is not, therefore, an indication that it reflects a reasonable relationship to economic value. But a proxy might be what consumers are prepared to pay for the good or service in an effectively competitive market. And then by way of explanation for this link between economic value and prices in a competitive market, reference is made back to the points we saw in paragraph 97, 1 and 2. An unfair price allows the seller to reap benefits not available under workable competition, and an example of such a price is one that bears no reasonable relationship to economic value. Now, pausing there, you've seen that in the present case, the tribunal described patient benefit taken on its own as a red herring. That's in paragraph 339 of the judgment. And that passage is heavily criticised by the appellants as wrongly dismissing the intrinsic value of the tablets as a life-saving medicine. We say that the tribunal's conclusion in paragraph 339 is in fact fully consistent with the court's conclusions on economic value in Phenytoin 1. Many immensely useful generic drugs are supplied for pennies. Patient value taken alone therefore cannot justify excessive pricing. The fact that customers have in fact been willing to pay high prices in a situation of market power isn't determinative. Instead, it's relevant to ask what customers would reasonably be willing to pay, even for a life-saving medicine, under workably competitive conditions. And in the present case, we have clear evidence of that from the prices that actually prevailed under competitive conditions by the time of the decision. The court then proceeds to consider and dismiss the specific ground of appeal that was before it on the basis that the tribunal's findings as to economic value were factual and within the range of conclusions that were reasonably open to it on the evidence. And at page 1279, there are some further relevant comments, starting at paragraph 171.
Can I just ask a point, as much
Yes, of course.
clarification as anything else?
Yes.
I've been quite careful so far to avoid making any statements about what sort of prices generic should be charged at in a competitive market, whether it is a cost plus or something higher than that, because I suspect we all know that if you go into a pharmacy and ask for paracetamol or something like that, you're not paying anything close to cost.
No.
You can say £1, £2, £3, and we all think it's good value.
Yes.
So you're not saying that in a competitive market, there will, even for a bog standard bit of chemistry, however beneficial, it has to be at cost plus.
I'm not saying that. We are here dealing with generic medicines, so we can put on one side
We're setting aside
Nurofen,
branded,
Paramol, and
still.
yes. And of course, for the unbranded generic aspirin and paracetamol, taking cost plus into account, I suspect one would find that the prices did bear some reasonable relationship to cost plus.
But I mean, I know if you go into any shop, you'll find the price probably varies from £1 to £3.50.
Yes.
But does anyone care?
Indeed. In this case,
Well, it's not 20 quid or 30 quid or 40.
no, indeed, it's a price at or approaching cost plus, and the convergence of those figures in my submission is telling. It's at or approaching cost plus, not only for the skinny label, but also for the full label, not only for the other generics, but also for Actavis's product. It is a clear indicator, or the tribunal was entitled to take it as a significant comparator. And if one needed authority for that proposition, in my submission, these paragraphs of phenytoin 1 supply it. It's a good proxy on the facts of this case, indeed. And I'm not making any wider submission now. The facts in this case, you have my submission, they were clear cut by reason of this factor, which in my submission, the appellants on their feet were really unable to answer when your lordship put it to them. They shifted to other grounds of value.
Can I just explore something which is very basic? But
Yes.
the comparator, the proxy that was talked about in phenytoin 1 is the price that this product could reasonably expect to achieve in workably competitive market. So one's not just looking at the price of comparables in that market, you're looking at the price that this product would be expected to achieve in comparison with those. Now, but in this case, you have that evidence, because once the price is reverted, the end of the period, I'm looking at the graph on page 1750, you then have a period of work of competition which shows the prices that were achieved by Accord UK and others. But importantly, it's still at a premium, isn't it? I think on the graph, it's always shown as higher than comparables.
By the time, we can go to the Matterhorn in a moment, by the time of the decision, my submission is that once competition had an opportunity to decontaminate the lingering effects, the prices of all of these products, including the Actavis product, had come down to within the cost plus range.
So if you take the graph beyond April 2021, because on this graph, it's only marginally higher, but it's always higher.
It's very, very slightly higher, it's true, but if you look at the where it lies, by comparison with cost plus.
Decision.
Yes, that's by the time of the CMA decision.
So we need, somewhere there's a graph, it takes it through to 2021.
That's right. So I don't know if you still have the Matterhorn figure to hand.
That's what I'm looking at.
So I apprehend that my lord's referring to the red solid line.
Yes.
And your point is that sits some little way above the 20 milligram.
Yeah.
Prices seem to be stabilising, although there's still a downward trend. And the level is, I don't have the exact figure, we can find it, it's around £4 or £5. If you look across at the cost plus lines, those are the base lines, these very low lines throughout the period at the bottom of the chart. You can see that price is around the cost plus range that the CMA applied. costs, it's referred to as costs on this table, but it's actually the cost plus measure. It's not just the marginal
But
cost
it's
measure.
very slightly above.
Very slightly above. And the tribunal...
4 and 5 or something like that.
Yes, and the court will have the point that an infringement was found in this case at above £20. So many multiples. And in my submission, once one gets down to levels of this order, it's not an unreasonable conclusion to say that prices bear a reasonable relation to cost
Yes,
plus.
and this isn't a point against you, I don't think.
No.
Because the differential builds in, if there is any economic value in full label,
It's reflected.
it could be said it's reflected even when it comes back to base level, not the end graph. That's the point.
My lord, I respectfully concur.
This is the table, that's the exact.
Yes, if you'll note, my lords, the table with the exact figures is at page 1074 of the core bundle, at the top of the page. This is in the decision. Maybe we go briefly to it. Core bundle, 1074. And you see here the cost plus is between 217 and 445, and you see Actavis's current prices as a weighted average from February to April 2021. It's a confidential figure, so I shan't read it out, but you see that it is
In the range.
I would go further. It's towards the
bottom of the range.
Yeah.
You said that you took the decision at assuming a £20 limit. That was for purely administrative reasons. Does it have any legal significance above that? So you're not saying that anything below 20 is or is not abusive. It was simply you were adopting a cautionary level, which is the same thing that happened in Zacaroli.
Yes, so absolutely right. It doesn't express a view as to what happened afterwards.
It's just pragmatic.
Yes, but it does give confidence.
In fact, at the beginning of the period, it's not, but it's slightly more than 20, isn't it? Very slightly. Or maybe not. Difficult to tell. The red line is obscured by the blue line.
At the start of the infringement period,
Yeah.
it was the £20 was chosen at each end as the starting point.
Gotcha.
Yeah, I mean the figures are a little bit imprecise from month to month, and they jump around a little bit.
Zacaroli, the 20, I think it was 2043, was taken simply because it reflected a price point at a particular point in time.
Yes,
But it was adopted purely for administrative convenience, as here.
it was, but in my submission, it can give some confidence in terms of the reasonable relationship with economic value. Now,
Were you going to show us the various points that you were still in?
yeah, there was just one more point to pick up in Fenatone 1, a very short point, paragraph. It's just to finish at the point on economic value. It's page 1279. Oh, sorry, in the authorities bundle. And at 171, at C in the margin, the court considered that economic value is an economic concept which describes what it is that users and customers value and will reasonably pay for. And the short point here is we say that the three scenarios that the tribunal identified as a multi-member panel, including an expert, a distinguished expert economist, were unsurprising in view of the indication that economic value is to be considered from an economic perspective. I'll show you in the judgment. I don't think they in any way distorted the legal analysis, but they're unexceptionable given the economic nature of the concept being considered. Paragraph 172, the court disagreed with the tribunal's view that economic value needed to be dealt with separately from the other components of the test. Picking it up at D, it considered that economic value is a part of the overall descriptor of the abuse, but is not itself the test. The test should therefore, when properly applied, be capable of evaluating economic value. So, for instance, as the CMA argues, when evaluating patient benefit, it would be possible to measure its economic value in the plus element of cost plus, or even in the fairness element. Equally, if there is evidence of the prices being charged in relevant comparator markets which were effectively competitive, then those prices could be capable of acting as proxy evidence of the economic value of patient benefit. So again, reference to evidence of prices under competitive conditions as a suitable proxy for economic value. And at the end of the paragraph at H, down the page please, economic value needs to be considered, needs to be factored in and fairly evaluated somewhere, but it's properly a matter which falls to the judgment of the competition authority, or in this case the tribunal, as to where in the analysis this occurs. And we say the tribunal was therefore permitted to consider economic value as part of the overall assessment of fairness, and to consider the comparator of subsequent pricing of hydrocortisone in competitive conditions for the purposes of assessing economic value. Second authority is Synven, the liothyronine drug, and this builds on the conclusions of phenytoin 1, confirming that a substantial excess above cost plus can itself serve as a benchmark of economic value depending on the economic context and provided relevant comparators are taken into account. So that's in Authorities Bundle, Volume 5, tab 61, page 2007. And at 2011, the court starts with page 2011, please. The court starts with an overview of the case, and it sets out the CMA's analysis of fairness and cost plus. In paragraph 9, the court recalls that the test in law is fairness, a protean concept. There are various methods that can be used to determine what a fair price is. In this case, the drug in question is long off patent. There was no requirement for any real innovation. There was a fixed and predictable demand, which was highly inelastic and did not go down as prices went up. And there were high barriers to entry, which served to protect the incumbent dominant undertaking from competition. And the short point here is that the features described, long off-patent drug, no innovation, high inelastic demand and barriers to entry, also applied in the present case. And I'll show you in a moment the tribunal's findings about this, which endorsed the CMA's analysis in the decision and was one of the factors it considered to raise an evidential justificatory burden on the appellants. The court then continues that the CMA considered that the appropriate way to determine a fair price was to apply the cost plus test, and that's then described. The CMA calculates the cost of production with a reasonable rate of return. It compares the resultant cost figure with the average selling price to see whether the margins were excessive, and if so, it considers whether the prices were unfair in themselves or by comparison with other products. It takes into account any considerations that might be relevant to the value of the judge. And we say that's precisely the approach the tribunal took in this case, the same two-step. At page 2014, paragraph 18, the court records the position of the CMA and the CAT. In the final sentence, one sees that, in particular, the tribunal endorsed the CMA's finding on cost plus as an appropriate benchmark for determining a workably competitive and fair price in generic pharmaceutical markets. And the court then in turn endorses that position as permissible and consistent with principle. One sees that at page 2034 in paragraph 76 under the heading the role of workable competition as a test for fairness. And the court's here addressing the appellant's argument that any price generated in the absence of dominance, collusion, or insurmountable entry barriers should be viewed as workably competitive and therefore a determinative benchmark of fairness. The court rejects that position, picking it up at the top of page 2035 in the second line. The court says there is no rule that a regulator or court must seek out evidence of what might happen in an actual market said to exhibit the features of workable competition as a benchmark. The premise which underlies the applicant's graphic depiction of a bright line test is thus unsupported in the jurisprudence. The case law, as summarised in Pharmaceuticals 1, describes practical approaches to determining fairness as the legislative test. It's understood that to make the law practicable, there must be evidential proxies to determine what a fair price would be if generated in sufficiently effective, workably competitive conditions. And then as one such proxy, the court confirms in the penultimate sentence that in an appropriate case, cost plus is a valid and sufficient way of establishing whether prices are fair, and to this extent can be said to reflect those that would be generated in a workably competitive market. So what lithironine makes clear in my submission is that cost plus can be in itself a sufficient way of establishing fairness and is another suitable proxy for the value that would be generated in a competitive market. In the present case, the tribunal found that prices for generic hydrocortisone tablets were unfair at prices very materially above cost plus. The appellants complain that its approach collapsed into an exclusive reliance on cost plus and neglected demand side value. But as this passage in the lithironine judgment shows, the tribunal could legitimately take account of the substantial excess of price above cost plus as an indicator of unfairness, a point that it explicitly drew from the case law at paragraph 3312 of the judgment. In any event, the tribunal's analysis did not end with cost plus. It also took account of the evidential proxy provided by post-entry pricing and a further evidential proxy, and that is, we say, a further evidential proxy which the tribunal was clearly entitled to rely on. So its approach was consistent with principle. Looking down at paragraph 79...
That's essentially what we found on the facts in Pharmaceuticals 2.
It is, indeed.
Which is that, if you like, in an extreme case, the bottom line, the floor price, for the floor threshold may be cost plus, but it may not be.
Yes.
There's absolutely no rule whatsoever, and I know we confirm very explicitly, and you acknowledge this, that there was no presumption that cost plus was abusive, but it purely is a question of fact.
One looks at the circumstances, and we say that the tribunal looked at circumstances that are validated by the case law. The nature of the market, in lithironine, a generic product long off patent, a factor that the tribunal expressly considered, as I'll show you in a moment, as an anomalous price, as a factor to indicate that the pricing was anomalous and required an explanation. The substantial difference from cost plus, which is an indicator of unfairness, even if it is not dispositive on its own. And actually that's very clearly shown by another paragraph in the lithironine judgment, which we might go to now. It's at page 2080. And you'll recall that one of the arguments in lithironine was that there was a failure to respect the burden of proof in relying on cost plus. Right. And the court returns to the interplay between cost plus and comparators at paragraph 199. So it's looking at the relative value of cost plus versus alternative benchmarks and comparators. The acceptance of cost plus has been acknowledged in jurisprudence for nearly 50 years as providing accurate evidence of pricing in a workably competitive market. And reference is made back to paragraph 77, which I showed you. And the court says that case law cannot now be gainsaid. Pharmaceuticals made clear that in an appropriate case, cost plus could be sufficient standing alone to establish excessive pricing, but also highlighted the desirability of cross-checking any one piece of evidence against other pieces of available evidence. So, 2 points that I take from this. Firstly, cost plus is a relevant factor for assessing fairness and economic value. Whether or not it's dispositive can be dispositive in an appropriate case, but it's clearly relevant. If there's a substantial disparity, that in itself is a factor that can be indicative of unfairness. combine that with a consideration of other comparators, well, the tribunal did that in this case, and it relied on the comparator of the post-entry period and where prices had reached a convergent piece of evidence. And we say that's consistent with principle.
Do you, in principle at least, accept Ms. Ford's point that if the CAT treated cost plus, as it were, the test, as opposed to simply the floor, the lowest point at which you might, on the facts, find abuse, that they should be correct?
Absolutely, yes. Yes, but in my submission, that's not what the tribunal...
So the question is, they wanted to simply work out what the CAT did?
Yes, indeed. On phenytoin 2, there are just a couple of points in the... These are, of course, I take your lordship's point that these are acutely fact-sensitive cases, and one can push the facts of one case, or that one can push these cases too far if one tries to build hard propositions of principle where they're heavily dependent on the factual context. But in my submission, given that the context is quite similar, we are dealing with generic pharmaceutical products in all three cases, one can look to see how the court analysed factual elements from the perspective of principle. And there are 3 points in phenytoin 2 that we say are illuminating. So the first is in, I think you have this loose, do you?
Yeah.
I have an unnumbered copy, so...
Just give us the paragraph number.
Yeah, 286.
Paragraph 286.
Apologies, sorry. Forgive me, I have a wrong reference there.
286 is really about the willingness to pay point.
It is. I think I may be in the wrong. Let me explain it. Paragraph 286 was indeed the passage that I wanted to take you to. Just find my copy if I may. Apologies. Yes. So 286, DHSC pushback point. So the court is here considering the relevance of whether or not the Department of Health acquiesced in the prices charged by Pfizer and Flynn. And the court notes that in law, if a purchaser is prepared to pay a price well above cost plus, that might indicate that it sees value or benefit in the product or service for which a premium is warranted. Where the buyer is large, sophisticated, and it might be said well able to look after its own interests, that might form part of the evidence supporting a conclusion that the price paid can be treated as reflective of workably competitive market conditions. Pfizer therefore argued that the fact that the state was prepared to pay the £30 DT price was a compelling indication that the price fairly reflected value. But the court proceeded to reject this argument, as was made clear in phenytoin 1 and has more recently been addressed, this is at the foot of page 76, more recently addressed in the Paterel, paragraphs 71 to 76. The fact that a buyer pays for something is not an indication that the price paid is fair. It could simply reflect the exercise of compulsive market power by the seller. And that was the CMA's concern. Is it any different if the buyer is the state? In Sinvan, the CAT held that it was not, a conclusion upheld on appeal. So again, the willingness to fund life-saving medicine at prices well above cost should not be taken to indicate that the value is fair in the sense of a price that would prevail under competitive conditions. It may result instead from the exploitation of a dominant position. In that vivid phrase, the exercise of compulsive market power. And we say that this supports the tribunal's red herring analysis of patient benefit in the present case. Given the evidence as to the prices that have prevailed under competitive conditions, one cannot conclude simply because the medicine is a life-saving drug, as phenytoin was, that there was intrinsic value that justified the high prices observed.
These cases, I mean, particularly phenytoin 2, was slightly different in the sense that there was a strategy to move the product from the PPRS into Scheme M, and that then structurally gave the suppliers the ability to price more or less at will, because the assumption around was not Scheme M, Scheme S. Scheme S was operated on the assumption that pricing was competitive.
So, my lord, yes, and that was the strategy that Auden McKenzie also took when it withdrew the original product
On the PPRS.
It was precisely to allow it to price at liberty, and it proceeded to. That's how it was able to get its prices to the astronomical levels that one observes in the Matterhorn. And then, if you look on to page 86 at paragraph 330, little Roman 4. Sorry, it's page 90, I think.
Sorry, paragraph 86.
No, paragraph 330, little Roman 4. Here the court briefly considers the implications of medical benefits for the pricing of generic pharmaceuticals and rejects any simplistic assumption that such benefits would automatically justify a premium. If I could just ask you to review that paragraph, please. So, little Roman 4 in 330. So, depending on the facts, the reasonable rate of returning cost plus could already take sufficient account of the value of the drug. Even if it did not, one would need to consider how that might be evaluated in the case of a generic medicine long off patent and subject to no investment or material improvement over the course of many years. And the court describes as a bold proposition the claim that the price of such a medicine should exceed cost plus, and notes that it would be inconsistent with the tribunal's own position in the liothyronine case, for the CAT to adopt a new position would require full exposition. Now, in the present case, as we'll see, the tribunal arrived at a conclusion consistent with the tribunal's approach in liothyronine, having pointed to the similar stage of the generic life cycle which hydrocortisone tablets have reached. And we say that that is a position endorsed by these comments of the Court of Appeal in phenytoin 2. The final point concerns whether a regulatory quirk that happens to confer market power on an undertaking can properly be equated with economic value. And your lordships will recall that one of the features of the market in phenytoin was the continuity of supply guidance. That discouraged doctors and pharmacists from switching patients from one manufacturer's phenytoin product to another, given the narrow therapeutic index of the product and the risk of small variations in dosing and excipients. And the effect was to give Pfizer and Flynn a substantially guaranteed customer base. The tribunal in phenytoin 2 considered that this continuity of supply might constitute a source of distinctive value for which some premium might be charged. And the Court of Appeal staunchly rejected that. One sees that in particular from paragraph 267.
I think we were critical of the CAT for, on the one hand, saying it was, and on the one hand, saying it wasn't.
Well,
continuity of supply was viewed as one of the intrinsic features of dominance and market power, which then gave rise, as the CAT then said, to an egregious breach. But then it said it was a matter of economic value. We were slightly puzzled by that.
Yes. So that is the point. How can one but it is the inconsistency that the tribunal, that the court was observing in this paragraph. I mean, we needn't. You have the reference, paragraph 267. I think the same point recurs in paragraph 330, little Roman 5.
I mean, at base, we were not saying it's incapable ever of constituting a benefit.
No, indeed.
But
the point I
said was it needs to be, if it's to some degree, possibly 100%, possibly less, is captured in the RROR of plus.
Yes.
If not, then the decision maker needs to see the evidence to see how it's valued.
Yes, no, I fully appreciate that. You were a court of principle and you were not making determinations of fact. That's clearly correct. But you were observing an inconsistency between, on the one hand, describing a feature of the market as conferring dominance and as a regulatory constraint on competition.
Exploitation over price.
And on the other hand, identifying it as a source of economic value. Now, the tribunal in this case did not fall into that trap. I'll show you what it said about the regulatory quirk. You heard...
It said it wasn't value, it was part of the dominance.
Exactly. And we say that position, the position it took in hydrocortisone, in the hydrocortisone case, was on the right side of the consistency that your lordships required in the phenatoin 2 case.
Yeah, understood.
And my point is that the appellants are on the wrong side of that inconsistency when they rely on the full label, skinny label distinction as a source of economic value. It's no such thing. It's the factor which conferred dominance. And the CAT made very clear findings about it to the effect that it was distortive of competition, that it was misbegotten regulation. They use really stark language to describe it. Those were findings that were within their province as a fact-finding body, evaluative body. And we say that they completely demolish any suggestion that value can be attached to the full label designation for the same reasons that gave the court concern in phenatoin 2. So that's all I wanted to say about the case law. Can I now turn to the three issues that are in my bag? First, issue 2A, the test applied by the tribunal. So this is whether the tribunal applied the wrong legal test in concluding that prices were unfair. And the applicants, appellants, object in particular to the three case scenarios the tribunal identified when considering economic value from an economic perspective. They say that this led the tribunal to neglect demand-side considerations, apply a conclusory approach, and adopt an inappropriately rigid framework of analysis. Now, on inspection, we say that the tribunal correctly directed itself as to the law in the judgment and was not led into any discernible error by its three cases. So if we could go to the judgment now, please. Crawl bundle.
What is your view of the three cases? You've been somewhat restrained in your written submissions about them.
Yes.
As was the cat in the Petorel. But what is your, coming off the fence, what's your view of them?
They're unexceptionable. They're hard to fault from an economic perspective, and we don't take issue with them from that extent. If they can be criticised at all, it is on the basis that they don't take the test very much further. They clothe it in different language. They say there has to be identifiable value which justifies economic value, which justifies the price in a context where pricing is excessive. And they can't simply reflect, and they can't simply reflect, as your lordship put it, the compulsive exercise of market power. Well, I mean, it's hard to, I mean, that sounds a little bit like motherhood and apple pie. It doesn't take one very, it gives a few illustrative examples, which are helpful along the way. The tribunal can hardly be criticised, you have my submission about this, as a body with an economist on it, for venturing some thoughts about a concept that was described as economic in Pharmaceuticals 1. The only question really for your lordships is whether that framework was applied with some rigidity, which then distorted the subsequent analysis. Yes.
The statement of the law is the tribunal actually states what the legal principles are, and as I understand it, doesn't actually misstate the legal principles.
Yes.
And then the issue is whether the framework of these three cases somehow leads them astray away from the correct application of the law.
Exactly
and
so.
Looking at it from my own personal view was, this is overcomplicating the whole area, and it runs the risk of being too much of a rigid framework that could lead to misapplication of the law. But the real question is, has it done so here?
Yes.
And it seemed to me that it's on first blush, it hasn't.
Yes, I respectfully agree and would endorse that analysis.
It might have been better if they hadn't engaged in the three-case framework. But
there's always a risk, isn't there, in ex cathedra statements, in a context that is highly fact
well, as you've shown us
specific.
in the earlier authorities, it's all dependent on that. You've got a series of principles, but there is how you apply them to specific facts.
Yes.
And even in the context of generic pharmaceuticals are out of patent.
Yes.
You can't just say, oh, there's a rigid test to be applied in all cases.
I would again respectfully adopt that proposition.
Yeah.
If the criticism boils down to a complaint that this adds little and risks overcomplicating matters, I wouldn't dissent from that, but I would strongly endorse the view that the tribunal understood when it came to the law that it was applying competition law and not competition economics. It understood that all relevant factors had to be taken into account, and it's very difficult to pin down where it said that any error arose as a result of the taxonomy. So just to make those points good briefly, I don't want to labour the point because I think your
Comes
lordship's
down to a point of construction of the judgment.
It does.
Did they treat it as the test? Were they adding their own, they identified the test and then added their own economic glossification?
Yes. In my view, that's exactly what they did. They did relate the test to the vocabulary that they had adopted from the economics producer surplus, consumer surplus, for example. But those really boil down to the question of whether the price is high, producer surplus, well above cost plus, or low, consumer surplus. We saw this point actually in Pharmaceuticals 2 when one stripped away the meaning of producer surplus. It simply meant the difference, as I think the court observes in Pharmaceuticals 2, between cost plus and the price in fact charged.
Yep.
So the vocabulary therefore adds nothing really to the underlying test. But just to make good the point that the tribunal did correctly identify the law, if we could pick it up on page 443 of the judgment. This is section J, where the tribunal addresses abuse. And turning on to 445, paragraph 308, the starting point identified by the tribunal is the decision of the CJEU in United Brands, and the key paragraphs are set out. Then over page at 309, the tribunal emphasises that it will turn later to the case law, after first making some remarks about the economic concept of economic value. So these are economic musings by a specialist tribunal with an economist on the panel. And none of the specific cases offered is problematic in itself from an economic perspective. So first, at page 449, the relative inefficiency amongst sellers. So the point is simply that if one seller is particularly efficient, it will be able to and may choose to enjoy higher margins than its competitors. Well, there's no, from an economic perspective, no possible problem with this. The only criticism that this Ford case C levelled at it was that it was a niche example and might be of limited application. Well, okay, that doesn't show error, legal error of a kind that this court need trouble itself with. Then at 2, over page, second case, generation of additional value from the perspective of the buyer. And as the tribunal explains at Little Roman 1, it intends this as a very broad category, embracing not just product differentiation, but any definable aspect of a seller's offering that adds value to the buyer. This is a passage that Intas has endorsed. And again, Ms. Ford didn't appear to take issue with anything specific in the discussion of case 2, and she in turn specifically endorsed the reference to distinctive value. And you have my submission that case 2 really is defined so broadly that it simply restates the question. Is there value in the product that could explain an excessive price, while offering a few illustrative examples? The suggestion in Auden's main case, I don't know if it was pursued orally, was that this case somehow neglects demand-side value. Well, one only needs to read it to see that's incorrect. The whole focus of the category is on what buyers value and are prepared to purchase at a premium, so the demand side of the market. And then the third case, on page 452 at point 3, high pricing without added value to buyers. That is to say, simple exploitation of market power, in which the ability of high returns to attract competition is inhibited in some way. Now, the worst that can be said about this is that it's again a conclusory category. It's the flip side of case 2. In other words, if there's no value and you've got excessive pricing in a situation of dominance, then that would suggest market power is the explanation. But it doesn't go any further than that in my submission. Another criticism that was raised was to say that...
Well, if you look at the last sentence, the very trite example where sellers combine rather than compete,
yes,
or a single seller is able to create barriers to competition,
yes,
which was a classic examples of abuse.
Well, indeed. Yes, and of course in this case...
This is just intended to be another way of framing the circumstances in which there is no justification for an excessive price.
Yes, because, and rather it reflects market power, which may or may not be the result of unlawful abusive conduct. Yeah. In this case, of course, there was anti-competitive conduct. It wasn't a point that the tribunal dwelt on because of the procedural tangle it got into, which your lordship resolved. Yeah. But it makes this the clearest cut of the trio of pharmaceutical cases. So one of the criticisms that was made was that there's no analysis here of proxies or comparators. But I think that simply goes to show that this isn't the bit of the judgment where the tribunal is considering the legal analysis. It's offering some framing observations. It does go on expressly and clearly to consider comparators and to recognise their relevance. Ms. Ford also, if we could scroll down the page, attached some significance to the footnote, I think, if I understood her submission correctly, at 402. But in my submission, the tribunal is here recognising that the distinction between the added value scenario and the market power scenario isn't easy to draw, And at the end of the paragraph, it's recognising that the determinative framework is not the economic framework, it's competition law that's decisive. So it's doing the precise opposite of what I think Ms. Ford was suggesting. It's saying the economics is interesting, but it's the law that we have to look to. And that's confirmed by the fact, in my submission, that on page 453, the tribunal immediately returns to the law. And in my submission, it here hits the right notes. So first, in paragraph 324, it recognises no bright line test or fixed definitive methodology. And that's with respect not consistent with the alleged rigidity approach suggested by the appellants. Paragraph 325, the tribunal correctly identifies the test as fairness. Quotation from Phenatoin 1, need to consider whether trading benefits would not have been reaped under conditions of normal and sufficiently effective competition, and whether the prices bear a reasonable relation to economic value. Now, of course, we saw in Phenatoin 1 that those concepts are linked, and they give you the proxy for economic value, what a customer would be prepared to pay under conditions of normal and sufficiently effective competition. So looking at a competitive market. The tribunal doesn't cite that bit of Phenatoin 1, but it reaches the same conclusion via another earlier Court of Appeal authority at the races. And one sees that on page 455 at Little Roman 2. Sellers of products are entitled to the maximum price they could command in normal and sufficiently effective competitive conditions. So in other words, where a competitive market would result in prices which are significantly above cost, then sellers ought to be entitled to hold on to the profits that they would thereby obtain. And at the start of Little Roman 3, the observation that this is consistent with the approach taken in Phenatoin 1. So this is the reason why one looks to the proxy of pricing under conditions of competition. And there was some discussion about what the tribunal may have meant when it referred to pro-competitive justifications at paragraph 340, if we could just go there. So you see in the third line down on page 461, pro-competitive reference to a pro-competitive explanation. Now, in my submission, that simply reflects that the explanation or justification for the excessive pricing must relate to some feature different from the exercise of market power. And that we say is
The
correct.
opposite of anti-competitive explanation.
It would be some feature that doesn't simply boil down to exploitation of market power, some other explanation that can be found.
It may just be loose language. One wouldn't normally say that that was pro-competitive, and that's just justification.
Yes.
To add the word pro-competitive suggests it's limited to some different type of justification, or there's only some justifications which the decision maker will accept and others which it won't.
Well, in my submission, whether the word is well chosen or not, it didn't affect the basic focus on justification.
Well, if you look at the footnotes in the description of what your case was
down the page,
it seems tolerably clear that what they are talking about, as you say, and as Malou says, it may be loose language. I mean, what they're really doing is saying, was there an explanation which was something other than the exercise of market power, which is illegitimate?
I'm grateful.
And that's exactly because you run through the possibles, as it were. So, well, nobody suggested any of these of those.
Yes.
Which would have been legitimate explanations. Perhaps you want to say legitimate.
Yes, legitimate would have been better.
I mean, the reason that we've been so careful not to limit evidence is because the system should be self-determining, self-justifying.
Yes.
If a defendant puts forward evidence and you accept it, then by definition it's relevant.
Yes.
And if you refuse it and the CAT then says, no, you got it wrong, again, it's a category of evidence which is accepted, and it would be very dangerous for a court, certainly this court, to try and work out in advance what a defendant might put forward by way of justification in a market.
Yes. Yes. No a priori.
No, the system should sort that out over time.
Yes. 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 And that's consistent, of course, with the rejection of a determinative benchmark in liothyronine.
Yeah.
So, just to go back to Ms. Ford's submission that the economic framework led it to overlook the relevance of comparators, that is, we say, incorrect. If you look at page 457, no single method for under evidence, as your lordship observed, when one comes to comparators, one is looking at the evidence that one uses to assess fairness. So it goes right back to United Brands, as I think you observed in Phenatone 1, the distinction between the basic test and then the various ways that one could operationalise it and the proxies that one could look to. And the tribunal's structure of the tribunal's judgment reflects that distinction. So at paragraph 330, no single method. At 331 will be affected by what is being valued, in other words, the nature of the product. And then at 3311, comparators are of particular importance. At 3312, the point that a price well in excess of cost will be an indicator of unfairness, and you have my submission that that's consistent with liothyronine, paragraph 199. And so...
The last sentence is the key. The question is whether anything probative can be derived. Derived. I mean, that's just it, isn't it? Whatever evidence, you get 1,000,001 different sources of evidence.
Yes.
And some are more probative than others. And often it's not binary.
Yes.
Comparators, as we had in Phenatone 2, I mean, you can have comparators which look comparable, but they're infected by some degree of market power, which you could strip out, turn them into something which is relevant.
Yes, the regression methodology, if it were needed. Very briefly to address you on that. In my submission, it was not a requisite under the burden of proof for the
there is that
CMA to advance. I'm going to come on to burden of proof, but just given that you've raised the point, there was no need for regression analysis in this case, in my submission, because you've got the best evidence from the during-after comparison.
At the start and end of the matter.
Yes. Yes. And that was sufficient. That in my submission was sufficient. So no error in the legal test applied. Yes, so I'm grateful. So, my Lord, in the final sentence of point 2, it's also clear that cost plus isn't determinative. Simply taking a cost plus approach may mean wrongly appropriating a producer's surplus to the consumer. It's a point the tribunal returns to, they certainly do not regard cost plus as the answer or in any shape, manner or form, or the exclusive answer. So turning to burden of proof. So the appellants say...
Is that all you have on the A?
On the legal test? Yes, subject to any questions your lordship has, yes.
So I think you may say that the tribunal having, in its legal section, recognised the importance of comparators and cost plus isn't enough. That's the end of it. But the point against you is, I mean, Ms. Ford went through the judgment very particularly, identifying where she said the CAT had nevertheless reverted to its case 1, 2, 3, ignoring the legal test. I think the point is when it came to make its decision on the facts, it didn't follow its own guidance in the legal section.
Yes. So, my Lord, I think that might be easier to address when I come on to explain the burden of proof point, because I do there take you to the circumstances that led the tribunal to conclude that there was a case a significant difficulty which needed to be addressed.
Yeah. Will you also deal with the point that the argument is the CAT only dealt with comparators when it came to the evidence as an afterthought, not as part of its actual reasoning?
Yes, I mean, in my submission, it did deal with comparators. It did address them, and it made specific findings as to which comparators were reliable and which weren't, having regard to the market circumstances of Clenadrin and the other products, its views as to pricing in the pharmaceutical sector.
Yeah, the question is, are you going to show us where they did that? Because I think at the end, the two paragraphs at the end are very brief.
So fortunately, Mr. Bailey is going to address you on precisely that question. He's coming on to the comparator.
Sorry, yes,
I'm grateful. Yes. On the burden of proof, so I think the allegation here is that having found that prices substantially exceeded cost, the tribunal effectively applied a presumption requiring them to show that their prices were legitimate, and that amounts to a mistaken quasi-exclusive reliance on cost plus, contrary to principle. Now, we say that's without merit. The tribunal recognised that the burden of proof was on the CMA, says as much in paragraph 34 of the judgment. On the facts, however, the tribunal identified 3 relevant circumstances in the present case, each of which called for an explanation and raised an evidential burden on the appellants. And we say there was no error in that. The first was the anomalous pattern of the appellant's pricing given the nature of the market at issue. That's explained at section F, in which the tribunal makes some general observations relevant to the whole liability assessment. So we're in section F, starting at page 359, apologies, 359. And at 1523, the tribunal provides a broad outline of the conduct. At little Roman 1, scrolling down, it describes the evolution of the prices as resembling a mountain. This is where the Matterhorn emerges. And over page at little Roman 2, it explains that this is because the high prices for the relevant products were bookended by low prices. And it describes this bookending as unusual. It notes that the usual evolution of prices, in relation to a pharmaceutical product. Normally, it is initially sold at a high price because it will be patented and benefit from the statutory monopoly that incurs. As the CMA decision describes, the development of medicinal products occurs in stages, beginning with patent protection and then moving to the entry of generic competitors, with prices being driven down. Reference is made to what is described as a helpful graph in the CMA's decision, figure 3.3. Then at little Roman 3, the tribunal avoids, for now, characterising the prices on either side of the mountain as competitive, as that would preempt the discussion of whether they were uncompetitive in the middle. But, says the tribunal, the phenomenon of pricing observed in this case is worthy of note and requiring an explanation. So, in my submission, the tribunal here recognises the important economic context of the case, which characterised liothyronine and phenatoin as well, namely a generic product long off patent, and the pricing trends observed are not characteristic of such markets. Just to take a brief detour to the decision to consider the materials underlying this passage, you've seen the Matterhorn, figure 1.4, and we've discussed the bookends, both at cost plus. The usual pattern of pharmaceutical pricing is different from this, and that can be seen from the figure to which the tribunal referred, which is core bundle at page 702. So this is, if you scroll down, the graph that was being referred to, and it was taken from if you scroll down a little further, you see the source was a European Commission market inquiry, the competition enforcement in the pharmaceutical sector. And if you scroll back up and look at the graph, you see the different stages in a pharmaceutical's life cycle, with the price shown by the dark blue line. And during exclusivity and patent protection, you have a high price, and then once exclusivity expires, the price normally goes off a cliff edge and goes down to a much lower level. And it's worth keeping in mind, of course, that in this case, the period since patent expiry had long expired. So the position is therefore set out in another figure in the decision at page 716. This is a presentation by one of the counterparties to the anti-competitive agreements entered into by Auden McKenzie, AMCO. And you see the on-patent period. Can you scroll down a little further to look at the figure, please? The on-patent figure shows prices high, and then it comes off patent, and the fall in prices leading to stable low pricing in long post-patent expiry products. And then in some markets, the potential for prices then to be increased long post-patent expiry. You see that on the right-hand side of the page. An increase made possible, as explained in the box below the figure, by strong barriers to entry and niche products ensuring pricing power. Turning back a couple of pages to page 714, you see that this was indeed Auden's strategy. If I could ask you please to review paragraph 3.92. Sorry. 715. No, it's not. It's one reference. There's one other. Oh yes, 391. Apologies. On upper page, 391. If you could please review that paragraph. And then if you could scroll down, there's a point C just across the page. So a strategy of selling niche high-margin drugs in which customers have a reduced ability to source alternative suppliers. And the resulting price increases for hydrocortisone were, as the CMA and the tribunal both recognised, anomalous for a generic product long off patent.
So this didn't follow the normal curve because the generics didn't. I mean, the price did fall, but that's because it was price controlled, wasn't it, during its branded period?
The price began low, as one would expect.
Well, if you go way back, it was high in 1955.
Perhaps,
it came off patent in 1975.
Went right down.
And generics didn't enter the market at that stage.
Generics didn't enter, that's true.
So, but that's, I'm slightly, well, why is it they didn't, and why is it they didn't once Auden came on the scene? We know they didn't from 2011 onwards because when they tried, they were prevented by the anti-competitive agreements.
Yes.
But is there an explanation for why they didn't come onto the market before then? Are there barriers to entry, or is it just this is so niche no one bothers?
Relatively low volumes, and it was being supplied adequately at a reasonable price by the incumbent.
And that's the point, isn't it? If when it came off patent between 75 and later,
yes,
it's a period of more than 30 years, presumably it's because Merck or whoever was actually manufacturing it at the time had the marketing were producing it and selling it.
Yes.
At 70 pence.
Yes.
A tablet or.
Yes.
And so there was no incentive for anybody else to come into the
yes.
market because they couldn't have made any money.
Yes, I accept that, but one can't justify. It takes us back to life irony. One can't justify very high pricing on the basis that it might then incentivise.
Oh, sure. I'm not suggesting it would, but
no.
It's just the explanation.
Yes, indeed, my lord. Yes, no, I agree.
And of course, once you get to the Auden McKenzie period, you've now got prices going up. You can see why generic manufacturers might very well, the skinny label manufacturers might very well think, here's a market for us.
Yes.
Get in there.
Yes, if they weren't bought off I agree
Well,
with
that's a different point.
Can I track this back to your point of departure, which is in the context of burden of proof, is the point that if you can establish as the decision maker evidence that something is anomalous or prima facie probative of inculpatory abuse,
Yes.
then you're on the way to saying, well, that then requires a justification.
Yes.
There may be a second limb to this, that if the justification relates to evidence which is peculiarly or better in the hands of the defendant undertaking, then you can expect it to put that evidence forward.
Yes.
What would be the case if the evidence was as much in your hands as their hands? Would you accept there was a burden on you to go out and find the evidence? I mean, quite often, for example, comparator evidence from elsewhere in the European Union.
Yes.
Probably you can get it from the regulators elsewhere.
Yes. So I agree that where the evidence is in the hands of the undertaking, it is reasonable to expect them to bring it forward, and that's not a reversal of the burden of proof.
But that's the
It's simply
evidential
to
burden.
require
That's
them
well
to
established in
explain.
just common
Indeed.
law jurisprudence.
Yes.
That if when it goes back actually to 18th century jurisprudence, if it lies in the hands of X and they've got it within their ability to adduce it, and they don't, then you can't then say the other side have failed to meet their standard of proof.
Yes.
But it rather, and I think the same point was
Yes.
made by the Supreme Court in Merrick's case on the myth.
Yes.
That it really depends in whose
Where
hands
the
it
evidence
lies,
lies.
where the evidence lies.
Yes.
It's
Yes.
a common sense approach.
It is a common sense approach, and the fact that the European legal order arrived at the same conclusions as the
Well, we,
18th century English common law shows its.
well, the same point was made in generics, I think. I think
Yes.
we covered this in Sinvan.
Yes, yes, indeed. So I agree, and each case will turn on its facts. The extent of the duty of evaluation will depend on whether an answer has already been found on other bases. So obviously it's not an obligation on the CMA to pursue every possible investigative lead, and merely because a matter is alleged to be relevant, that it needs a minute investigation, that the answer may well lie in the material which is already available and before the authority. But subject to that caveat, I agree that the extent of the evidential burden and its positioning will depend on who has the evidence accessible to them.
And part of the procedural safeguard against problems at the regulatory decisional level is the fact you have a merits appeal.
Yes.
So that, which allows further evidence in, which was not before the decision maker.
Yes.
So the issue becomes slightly academic by the time you get into the CAT.
Yes.
That it is simply they're looking at any evidence, including that in the decision, and they just simply come to a conclusion on that which is before them.
Yes.
I'm sorry, can I just go back to this question of price rising?
Yes.
Rises after you've brought it off brand.
Yes.
The question is whether you're reaping benefits which couldn't be achieved in workable competition. So what's the problem in putting your price up bit by bit and seeing, well, let's see when someone else, I happen to be a monopoly at the moment, but I don't want to preserve my monopoly. I'm quite happy for others to come in. I'll push my price up a bit, see what happens. Nothing wrong with that, is there?
The difficulty arises where the prices reach levels that would not be obtainable if there were competition. But that doesn't require one to price in such a way as to achieve competition.
Do you have to ask the question, why isn't there competition? I mean, we know, as I said before, from a particular point in time, there wasn't competition because they were bought off. What about the period before that? Is it relevant to ask, well, why isn't there competition? Obviously, if there are barriers to entry, that would be one answer. But if there are no barriers to entry, just people are choosing not to come into the market, even though you're putting your prices up, at what point does it become wrongful?
So that will obviously depend on the evidence that is available at the time that the decision is being arrived at, which one would need to consider in the round. I don't think there's a bright line answer to that question. And of course, the case law tells us that it's not a requirement for the authority to specify what is a fair price. The question is whether the price has become unfair because it bears no reasonable relationship to economic value, and whether it is a price that would not prevail under conditions of competition. That price not being the price that would necessarily begin a process of entry. Because we see from the prior experience over many years of Merck that in many pharmaceutical markets, you have a supplier happily producing at levels that are reasonable and realistic, that don't attract entry. The question is whether one can justify prices rising very dramatically above cost. And here we do have a clear indicator, given that there was entry eventually, of where prices end up. And they do suggest that the prices found to be infringing by the CMA, endorsed by the tribunal, were not those that would prevail under conditions of normal and sufficiently effective competition.
The answer presumably comes back to that, yes, if you're not dominant, you can do what you like in terms of putting your prices up.
Yes.
But because you are a dominant, you're under a special obligation.
Yes. I respectfully agree.
We very much saw that in liothyronine, didn't we? The internal documentation demonstrated there was a desire to push prices up, test the extent to which third-party entry occurred. I think the companies found that it didn't occur quite as quickly as they were anticipating. And when it came in, they operated on the premise that it would probably prices would drop, but not back to the starting point, and probably reasonably slowly. So there was a whole period of a sort of a Matterhorn.
Yes.
During which you would be able, even during the glide path downwards, to earn high profits.
Yes, that's right. Yes. So the following entry, the bet by the
incumbents,
or the incoming generics,
the new entrants,
is that they'll cover the costs of obtaining the marketing authorization on the way down.
Yes, there was some evidence suggesting that the new entrants thought the price would not return.
Yes.
Because no one had an incentive. I mean, I think the analysis of the CAP was that they called it sticky or oligopolistic market subsequently, and there was no incentive for anyone to go back to cost plus.
Yeah, and that would depend, of course, on the number of how stable it was. Would depend on the number of entrants, which was unknowable by the.
It was chemistry which wasn't that easy to produce.
No.
I think.
Yes. Yes.
Anyway.
The short point that I'm seeking to draw from this passage of the judgment and the underlying decision materials is that the prices were anomalous for a generic product, and that raised an evidential burden. It called for an explanation, as the tribunal observed. The second circumstance was the undisputed and very substantial mismatch between price and cost plus a reasonable rate of return. The starting point for this can be seen in the judgment, page 444, paragraph 302. So the tribunal notes that the CMA's cost plus assessment was unchallenged. You saw the scale of the divergence from the figure in the decision. That was and is not contested. And the tribunal notes in paragraph 302, if excessive pricing were sufficient to show abuse, that would be no answer to the CMA's finding of infringement. And at paragraph 303.2, the tribunal noted that the appellants contested liability in part on the basis of the need to take account of economic value and portfolio pricing. And turning on to page 458, paragraph 333, the tribunal accepts that the first limb of the United Brands approach, excessive pricing, is met. One sees in the fourth line, the tribunal regarded it as significant that no appellant challenged the specifics of the CMA's finding. And at 334, the tribunal regards the CMA's conclusion that prices were excessive as unimpeachable and undeniably correct. It noted, however, that this was insufficient to find an infringement, so not just relying on cost plus. As the case law shows, that's all reasonable and correct. Cost plus can itself provide a sufficient indication as to whether the price bears a reasonable relationship to economic value. But there is no unlawful reversal of the burden of proof. It's simply that the appellants are required to bring forward their evidence as to the reasons that they priced as they did. The third circumstance identified by the tribunal as requiring an explanation was the temporal comparison provided by the bookends of the mountain. And the tribunal addresses this at 463 of the judgment in paragraph 349. And having rejected other comparators, on which Mr. Bailey will address you, the tribunal states that it does consider that the products themselves act as their own comparators when considered on a temporal basis. And we see that the tribunal considers that this too requires an explanation. In my submission, the tribunal was correct to attach significance to the bookend prices. It had identified from the case law that economic value may be assessed on the basis of what customers are willing to pay in conditions of workable competition, and the evolution of prices in this market shows that after a period of even imperfect competition, prices eventually stabilised at or around cost plus. So we say that the tribunal identified good and correct reasons why the material raised an evidential burden for the appellants and thereby engaged the evidential burden. On economic value, I'm going to deal very briefly with the four sources of value that are identified by the appellants. And we say that as an initial observation, the evidence of prices once competition took hold gives the best indication of the economic value for which customers would reasonably be prepared to pay under competitive conditions. And we say that is a short answer to them all.
Anything above the bookends?
Yes. The first alleged source of value is patient benefit, conferred by their product as a life-saving medicine. And they say that conferred intrinsic value. And they object to the tribunal's dismissal of it. Now, I hope you have my answer to this. We say the tribunal was right to dismiss patient benefit taken on its own as a demonstration of economic value. The case law clearly distinguishes between willingness to pay for a life-saving medicine. That is not enough in circumstances where the customer has no choice, and the price that the customer would be willing to pay under conditions of competition. And you see that point reflected in paragraph 339 of the judgment, page 460. So you see it, subparagraph 1, of course patients will value life-saving medicines, but that doesn't in itself justify a seller charging more. It may confer market power, given the low elasticity of demand, in circumstances where there are no or few substitutes. That's the compulsive market, exercise of compulsive market power point. And at point 3, the point emerges still more clearly. The appellant's proposition amounts to no more than this, because either seller can charge high prices to you, the buyer, and you, the buyer, must pay them. The seller is transferring value to the buyer. So in other words, just looking at willingness to pay for a life-saving drug without more risks confusing genuine value with market power. The line may be difficult to draw, but it unquestionably exists. And at paragraph 341...
Sorry, is there a linguistic point taken on 339 first sentence still or not?
Well, it's not entirely clear, but I must say, as I heard Ms. Ford's submissions, I saw the force of them when read in the light of willingness to pay more at subparagraph 1. So moving on to paragraph 341, the tribunal correctly focuses on whether the excess is consistent with a competitive market. In other words, what prices would prevail under conditions of workable competition, a question that we say finds an answer in the tribunal's temporal comparator, on which it relies at paragraph 349. The second alleged source of value is the proposition that Auden McKenzie rescued the product from being withdrawn by buying the market authorisation and making the product viable. Now, the tribunal didn't address this allegation in terms, but it is with respect obviously hopeless. Auden McKenzie was prepared to relaunch the product after acquiring the marketing authorisation at just above cost plus, so the bookend on the left-hand side of the Matterhorn. And that was clearly considered to be a viable price. The product is now being sold at around cost plus, again a viable price, and the temporal comparator relied on by the tribunal is therefore an answer to this alleged source of value. I should also note that for Auden McKenzie to say that it provided distinctive value by supplying a product where others cannot has a rich irony to it, given the factual context, in which for a number of years, another supplier was disincentivized from entering the market by generous and economically unjustified payments under an anti-competitive agreement. We say that Auden McKenzie was no white knight in the history of hydrocortisone tablets. The third source of value alleged is the full label authorization. You've seen that the tribunal regarded this as creating a competitive distortion, the Plenadrin orphan designation, an unearned benefit. It referred to the skinny label as labouring under a competitive disadvantage. It described this as a deficiency of the regulatory regime, and it regarded such a deficiency as part of the reason for dominance. The tribunal therefore concluded that this was not a source of economic value but of regulatory failure. One sees this in paragraph 351 as part of the discussion of fairness and economic value. And you see in the final sentence of that paragraph the conclusion, the fact that a misbegotten regulatory environment has engendered a dominant position, which is then abused, in no way justifies the abuse. And it therefore refuses to accept as a justification the features of the regulatory environment which is identified as dysfunctional earlier in the judgment. And we say that conclusion is consistent with the approach of the Court of Appeal in Pharmaceuticals 2. In any event, again, we rely on the temporal comparator. Prices of full label type tablets had by April 2021, the last available date included in the decision, fallen to levels within the range of cost plus. And the figures for your note are set out in the CMA's main skeleton argument, Core Bundle 1, Tab 8, page 160. Finally, Intas relies on the witness evidence of Dr. Burt, which was before the tribunal, and which they say shows that there were a number of what they describe as pro-competitive reasons why customers, as a general matter, valued dealing with them over other pharmaceutical suppliers. If you could please go to Dr. Burt's statement. It's in the core supplementary bundle at tab 16. And economic value is addressed from page 209. At paragraph 57, you see that Dr. Burt explains why pharmacies felt compelled to buy full label hydrocortisone. This was the paragraph you saw yesterday, and it confirms the assured customer base. And this is a consideration that is specific to the hydrocortisone product. But in a carefully crafted witness statement, it's notable that at paragraph 58, the other, up the page please, so foot of the next page, foot of the following page, or the previous page, there, 58, he says that there are various other non-economic factors that are relevant to the decision to do business with Intas generally in the generics market. And he then sets out a spectrum of what one might term generic considerations. None of them relates specifically to hydrocortisone. They are reasons to prefer Intas and not Intas's hydrocortisone product. And we say they therefore cannot be said to show any economic value specific to hydrocortisone that could possibly justify the huge discrepancy between price and cost and the large price premium that Intas was able to command as a result of its full label windfall. the lack of any specific economic value attaching to hydrocortisone is apparent from the fact that Intas, despite these general benefits, now prices hydrocortisone at around cost plus. And that shows how far those factors could bolster the hydrocortisone price under competitive conditions. So the tribunal's general reliance on the temporal comparator therefore encompassed this specific argument without the need to give it separate consideration. There was some reference to portfolio pricing. I'm very unclear about whether this is really maintained. Insofar as it's said to be a justification in its own right for the prices, that's clearly hopeless. There was no evidence before the... I'm so sorry.
There would have to be evidence.
Yes, indeed. As the court held in lithiaronine paragraphs 3, I'm sorry, I don't have the paragraphs, but it was a point that was specifically addressed in lithiaronine. There was no such evidence, as the tribunal pointed out in paragraphs 352 to 353 of the judgment. So we say portfolio pricing goes nowhere. The suggestion that it should lead to a cautious approach is, we say, just misconceived. It can add nothing. Economic value needed to be considered in any event, and it was. So, my lords, subject to the comparators point, which my learned friend Mr. Bailey will address you on, those are our submissions on fairness and economic value.
May it please the court. My submissions are structured under 3 heads. First, I'll deal with issue 2D and why plenidrin and hydrocortisone are not meaningful comparators. Secondly, I'll deal with issues 2E and 3 Roman numeral 1 as to why anticipated entry in 2015 did not bring to an end the abuses. And thirdly, I'll deal with issues 6 to 11 on why we say the penalties imposed by the CMA, upheld by the tribunal, were necessary and appropriate. If I can start then with comparators. On Tuesday, leading counsel for Auden showed the court paragraph 249 of its judgment in Phenatoin 2. As the court will recall, that identified 3 issues to consider. First, product characteristics. Second, the extent to which prices arise from workably competitive conditions. And third, if a comparative price is affected by market power, to see if there is any evidence that enables the price to be adjusted to strip out the market power element. I can start with plenidrin, please. I'd like to show the court how the CMA approached these issues. And we can begin, please, in the CMA decision, and that is at paragraph 5.406 on page 1183 of the core bundle. Thank you. And the first point is product characteristics. And my submission will be that plenidrin and hydrocortisone tablets are very different. Indeed, using this court's metaphor is like comparing tinned cod's roe with caviar. The caviar for this purpose is plenidrin. It was a new, innovative, branded product, and contrary to Auden's submissions, plenidrin was developed for a niche group of patients that did not do well on hydrocortisone tablets. My lords, if I can just show you paragraph 5.409 on the screen here, you can see that point being made by the CMA. Turn to the tin cod's row, hydrocortisone tablets, generic, unbranded, as my lords observed this morning, first sold in 1955. So we say right out of the gate, this is not a promising or meaningful comparison. My Lord, secondly, at paragraph 5.417 on page 1185, please, the CMA found no evidence before it that Plenadrin's price was set in conditions of effective competition. And there are two reasons for that. The first is Plenadrin was so expensive because, of course, there was only one supplier of that modified release hydrocortisone tablet, Shire. And the other point that's made in paragraph 4.418 is that it sits within category C of the drug tariff system, which is, as it is pointed out there, where there is no competition at all for the supply of that drug. Now, the CMA did not stop there. It went on to consider whether there was anything in the market context that could inform the use of Plenadrin, even though it is an eye-wateringly expensive comparator. And we can see, if we go back a page, please, this context is set out in paragraph 5.413, where one can see, down a bit please, thank you, Plenadrin is barely prescribed in the UK. Indeed, CCGs don't recommend its use, and it's not available at all in Scotland or in Wales. And the point that is made in the next paragraph, we say is important, Plenadrin was used by less than 1% of all adult patients suffering from adrenal insufficiency, and that was a consistent trend throughout. It was launched at the end of 2012 and right the way through to 2020 and beyond, it was always way less than 1%. My submission is that a product that virtually no one buys, the NHS, or takes, the rare patient, is a good indicator of fairness. My Lords, if we look at footnote 1853 on this page, you can see what the owner and seller of Plenadrin told the CMA, that Plenadrin faces severe market access restrictions, primarily due to not yet being included in primary and secondary care formularies. And so, in my submission, that belies the suggestion that Plenadrin was in any way competing with hydrocortisone tablets. Indeed, if one turns over the page, paragraph 5.415...
And in fact, that footnote goes on to explain how they tried unsuccessfully to have a launch through the Leeds area committee who'd given them the cold shoulder.
Exactly right, my lord. And then what is Shire's reaction over the page? 5.415, it gives up. It's no longer proactively promoting its product. And my lords, I won't take you to it, but you were shown paragraph 3.133 of the decision, just for your note, page 727 of the core bundle, and you were shown how NICE does not recommend Plenadrin. I just add, for your note, the Society for Endocrinology also told the CMA, footnote 186, that nearly 90% of GPs were not allowed to prescribe Plenadrin, and that its use in hospitals is extremely limited. And on that particular paragraph, it was upheld and endorsed by the tribunal expressly at paragraph 139 of its judgment. And for your reference, that's at core tab 16, page 354. But my lords, it actually gets worse for Plenadrin. Can we please turn to page 971 of the core bundle? It's page 323 of the decision. And can we go to paragraph, 4.73b is what we're looking at. And here the CMA sets out that Plenadrin was launched September 2012. And then what we observe in the second sentence is that after it's introduced, far from there being any competitive constraint, actually, hydrocortisone tablets, they just rocket on, onwards and upwards. The rate of price increases intensifies. And you can see how the reimbursement price actually goes up, not down, because of Plenadrin. And the same story is true for 20 milligram. And importantly in my submission, the last two lines, there's no switching. Even though hydrocortisone is going to stratospheric levels of pricing, no switching to Plenadrin whatsoever. And before I move on, my lords, I should address the third issue which this court identified in paragraph 249 about whether one can regress or adjust the Plenadrin price. And the submission made by leading counsel for Auden was that, well, that's not the end of the inquiry, and it's for the CMA to somehow regress or adjust. Can I make 3 brief points in response to that? Firstly, and helpfully, my learned friend Mr. Holmes, King's Counsel, has already anticipated that we say in this case, you have the product, hydrocortisone tablets, that is sold in workably competitive conditions of competition in 2021, and that is the ideal comparator, which means one doesn't have to waste time and resource for everyone, the parties and the CMA, on regressing an imperfect, and that's to be generous, comparator. It's a flawed comparator, inflected by ostensibly market power. And the decision makes this point, paragraph 5.403c, page 1182. The very strength of the comparator at the bookends detracts the weakness comparatively of the comparators relied upon by the appellant. So my first point is we don't need to regress because we have an identical product in conditions of effective competition, which means that that can be used as a barometer of fairness. My second point...
Just to comment, in paragraph 249, we didn't say anybody had to produce the evidence. We said that if there was evidence before the tribunal, then it would need the decision maker would need to take it into account. We rather beg the question of whose duty it was to put it up. Yes,
my lord. So I'm going to, yes, you're quite right. And actually, paragraph 261 of Pharmaceuticals 2, when my lordships address in that case, the question of the Teva tablet, you rightly point out that the tribunal and the CMA had looked at the circumstances of market power, and there was no need in that case to sort of unpick or strip out any ransom element. My lord, on the point you raise, my submission is that in principle it can't be right that an undertaking can come along with a comparator, argue that it is exculpatory on an all or nothing basis, and then say, over to you, CMA, you go and strip out the effects of market power. We're not even going to tell you how to do it. They haven't done that. There has to be, in my submission, some constructive engagement. So if one goes back to paragraph 97 of Pharmaceuticals 1, what this court then said was that, well, if the defendant comes forward with a comparable, and if, hypothetically, it had said, look, it's not perfect, but we suggest the following adjustments, then in my submission, then at that, the responsible authority needs to fairly evaluate the comparable and the proposed adjustments and engage with that. But that did not happen in this case. All that was said was, oh, look at Plenadrin. It is extortionate prices, and that justifies us charging less prices. That was the submission that was effectively being made on Tuesday. So in my submission, the evidential burden has to lie on the undertaking that is saying, this is a worthwhile comparator. And if it is in some way flawed because of market power, then at least in the first instance, there should be a good faith attempt to seek to regress or adjust that. Now, the response that was made on Tuesday was, but well, the CMA has the power to request information. And that was a point that was made to this court in Pharmaceuticals 1. And it's at paragraph 113, where for time I won't turn it up, but I'll just simply direct you to...
You should issue section 26 notices, I think was the argument.
That was the argument, my lord. And the response to it really is the one that the court makes, which is that the CMA's duty here to evaluate evidence is affected by the quality of the evidence that is put forward. Both my Lord Lord Justice Green makes that point in paragraph 114, and the Chancellor also made that point at paragraph 270. And both your Lordships and Sir Stephen Richards as well said there's a considerable margin of manoeuvre for the authority. It doesn't have to go out and proactively investigate. It has to engage with what evidence is put before it. And in my submission, that fits with the 249 of Pharmaceuticals 2, because once the CMA has a corpus of material before it, then it has to engage with that, fairly evaluate that, give reasons for either accepting or rejecting that. But in my submission, what it doesn't need to do is go off on a frolic triggered by an undertaking's assertion that somehow it has to then issue a blizzard of section 26 notices. That really would be counterproductive and wasteful of time and resource. So in my submission, for those reasons, Plenadrin is not a meaningful comparator, and the CMA addressed it. And what I'm going to now do is move on to my Lord Justice Zacaroli's question about the tribunal and what it said about this. And so you were shown on Tuesday paragraph 348, which was the conclusion of the tribunal, that it wasn't a valid comparator because its price was distorted. And you won't be surprised to hear I emphatically endorse that. What I'd like to show the court today is why the tribunal found that the price of Plenodrin was distorted. And so could we pick it up, please? This is the core bundle, volume 2, tab 16, at page 354. And just to situate ourselves, this is under the heading on the previous page, Implications and Relevance of Plenodrin. And you weren't shown this paragraph 139 on Tuesday, but it does in my submission make 3 pertinent points. First, and we don't need to look at the beautifully traffic light colour-coded Annex 3, but what the tribunal says firstly is that the price of Plenodrin was consistently well above 10 milligram and 20 milligram hydrocortisone tablets by a multiple of several times. So that's the price point. Second, the data, which was not controversial before the tribunal, showed no particular shift from immediate release tablets to Plenodrin, which supports the point my Lord Justice Zacaroli made on Tuesday about the reality here that Plenodrin was not competing with hydrocortisone tablets. And thirdly, the tribunal endorses the decision of the CMA that CCGs were doing their level best to ensure that Plenodrin was not prescribed by doctors. Now, my lords, you were shown later on in the judgment paragraph 243, subparagraph 8, subparagraph 4, and can we go there, please? That's at page 410 of the bundle. And this is the long paragraph where the tribunal sort of sets out its sort of approach to market definitions, an issue I'm going to come back to. But what we see in Roman numeral 4 is the point being made that without having to call it unlawful, nonetheless it is highly anomalous and also is not a competitive price. But the tribunal explains that on the following page. We turn over the page, please, in subparagraph B, which you haven't been taken to. This is explaining one of the reasons why the tribunal formed the view that this was a misbegotten regulatory environment, because we have the orphan drug status of Plenodrin, and you can see here the effect of this status was effectively to mean that Plenodrin was closed out from competing with the treatment of adrenal insufficiency in adults. And then the final point, the price of Plenodrin is therefore higher than it should be, certainly not a market price. So in my submission, that is what is underpinning and informing the tribunal's conclusion in 348 as to why Plenodrin is an unreliable comparator. Now, my lords, what is said against this by the appellants is that, well, the tribunal failed to take regard of its decision to include Plenodrin in the relevant product markets. And for your note, that's at 256, subparagraph 3. And they say that's because it implies some sort of pricing constraint between the products. My submission is that fundamentally misunderstands what, in fact, the tribunal did when it defined the market. Because my learned friend, Mr. Armitage, was explaining yesterday, to avoid the cellophane fallacy, what really the tribunal did was craft its own bespoke approach to defining the market. It avowedly did not consider competitive constraints from actual prices. You see that, paragraph 243, subparagraph 8. Instead, the tribunal hypothesized how a hypothetical consumer, wonderfully the characteristics of a doctor, pharmacy and patient, would respond to a notional 10% increase in an assumed prescription price per pack of £10. Now, as my Lord Justice Zacaroli observed on Tuesday, day 1, page 64, really what the tribunal was doing was examining substitutability, which is market definition, on clinical grounds. It was at no point grappling with the extent to which there was any price-based competition. And we can actually see this in the judgment at 2563. If we could turn that up, please. It's at page 415. I apologise, it's 416. Over the page, please. And this is where the tribunal is talking about why it includes Plenadrin. And you can see that there is a point made that, in essence, the tribunal considers that there are perhaps not many clinical disadvantages of using Plenadrin instead of the 10 milligram hydrocortisone tablet, and there are clearly some advantages for a certain group of patients. But in my submission, the key point actually is in the footnote, footnote 330, because there the tribunal observes that, I do apologise, it's not 330, it's 332 over the page. Yeah. It's where the tribunal stress that we will not lose sight of the fact that Plenadrin was sold at a price around 40 times higher than the price the tribunal is hypothesising, and the CCGs, they're the ones footing the bill, were opposed to prescribing Plenadrin on cost and not on clinical grounds. So in my submission, the market definitely...
That last sentence, the price of Plenadrin and the reason why demand was low, factors go not to substitutability but to dominance.
Exactly right, my lord.
So making the point that
it is
in the comparator, in the comparator for the purposes of the dominance exercise, Plenadrin was just not a comparator. But it doesn't follow that it wasn't a substitute within this particular part of the analysis.
Exactly right, my lord. I think, as my Lord Justice Zacaroli observed on Tuesday, the appellants are using this decision by the tribunal to include Plenadrin as a sort of leg up to help them with the comparable. And the problem is, there's nothing actually here to give the leg up. The market definition is on therapeutic substitutability. It is not in any way seeking to justify the price or say that the comparator is in any way meaningful.
It's the nearest we get to some form of progression, isn't it? To hypothesise, to attempt to strip out, as it were, the cellophane fallacy increment, and then identify a price which is hypothetical, and then see what would happen.
That's right, my lord, except that what the tribunal do is they, to avoid the cellophane fallacy, they have to take a competitive price. That's why they use the £10 price, which is for the focal product. Yes. What the tribunal doesn't do, because there's no evidence for it to do it, was to regress the Plenadrin price. They just say that we're going to assume, they say this in 2563, we're going to assume that Plenadrin will be at a lesser level, but no one was offering assistance as to what that lesser level would be. Yeah. So in my submission, this is wrong as a matter of law to suggest that Plenadrin is a valid, reliable and meaningful comparable, having been used by such a minuscule number of patients, and indeed, of course, is surpassed by the far better comparator in the form of competitive prices for this product in 2021. That's what I want to say about Plenadrin. I'm going to move to hydrocortisone. And again, I'll start with the CMA decision, and then I'll come on to the tribunal judgment. So please can we start in the core bundle, tab 23, at page 728. And you'll see under the heading, Other Forms of Hydrocortisone Medicine. And you'll see that other forms are not used routinely as a cortisol replacement therapy. And then in 3.135, the CMA found that injections are only used for that purpose in exceptional circumstances. And I do underscore that, where oral medication, such as tablets, are not tolerated. And then you can see there the exceptional examples that are given. The other point I would draw to your Lordship's attention is the last two sentences. One such injection is hydrocortisone. And you'll be struck by the fact that it is primarily used for arthritic conditions, not treating adrenal insufficiency in adults. Yeah. In fact, not used to treat long-term adrenal insufficiency at all. And in the footnote 195, thank you, what you'll see, the SPC refers to the summary of product characteristics. That's the sort of the label that you will see stuck on a box of, or here, an EpiPen. And what it says is, just to confirm that point about what actually is hydrocortisone used for. Well, it says it there. it's to use to treat arthritic conditions. So my submission is twofold. Here again, the CMA addresses the product characteristics as envisaged by para 249 of phenytoin 2. But here what we see is that the comparator is used to treat primarily a different condition, arthritis, and only exceptionally used to treat adrenal conditions where tablets cannot be used. Now, it is fair to say that hydrocortisone was not really developed in that much detail during the administrative phase of this case, and that is why it is dealt with in one, albeit somewhat lengthy, footnote, to which I am now going to come, and that's on page 1181. And this is where the CMA is addressing fairly the various comparators being put forward by the parties under investigation. We go to the bottom of the page, please. There is the lengthy footnote, 1842. And it makes a number of points, but can I start, please, at the end? Because what the last 5 lines tell us is that, like with Plenadrin, the CMA found no evidence that the price of hydrocortisone was subject to conditions of effective competition. As with Plenadrin, there is only one supplier of hydrocortisone, that's Amco. And as with Plenadrin, it sat in category C of the drug tariff, which we know is the one where there is no competition for the supply of the product. And you'll see the last point there, like with Plenadrin, there is no competitive interaction between hydrocortisone and hydrocortisone tablets. And so my submission here is that the CMA addresses the second issue identified in paragraph 249 of the judgment in phenytoin 2. Now, on Tuesday, leading counsel for Auden showed you various excerpts from section 26A interviews conducted by the CMA with Mr. Patel, he's the former owner of Auden, and Mr. Barnard, the former head of sales at Auden. And his important interviews took place in July and September 2016, so 8 years after the events in question when the abuses began. It's important to add, Mr. Patel and Mr. Barnard were not called to give evidence to the tribunal. So you were shown a witness statement that was duly put to the CMA, but no sworn evidence was provided to the tribunal. The CMA couldn't cross-examine either of these individuals. They interviewed them, as you've seen. But for me, the critical point, which is the one that's made at the beginning of footnote 1842, is that, yes, those individuals made claims that they had somehow looked and benchmarked against hydrocortisone, fairly vague claims about a pharmacist telling them about it. But there were no contemporaneous materials whatsoever that backed up those claims. As the tribunal made this point in the Nat case at paragraph 252, it is reasonable to expect that if a company says it did something, here that Auden claimed it set prices by reference to hydrocortisone, one would reasonably expect that to be set out in the internal documents at the time, and there was nothing. So my submission is that there really wasn't any material here to engage the CMA's duty, but it did fairly evaluate the evidence that was before it in terms of the product characteristics, in terms of the competitive conditions, in terms of the claims made by the witnesses, which were found to be unsubstantiated. Now, if I may turn to the tribunal, it was suggested on Tuesday that hydrocortisone was not considered at all. Please can we go to the core bundle, tab 16, at page 319. You'll see a heading, Other Forms of Hydrocortisone, and you'll see a reference to hydrocortisone and describing it as an injectable form of hydrocortisone. And then you'll see what we've already looked at, which is a quote by the tribunal of the finding made by the CMA in its decision, emphasising that it's only ever used for adrenal insufficiency in exceptional cases. And pausing there, The tribunal explains in paragraph 19 of the judgment that where it quotes and cites the decision without in parentheses the abbreviation ref, it should be taken to agree with and endorse and uphold the finding. And that is what, if you look at footnote 50 and 51 at the bottom of the page, you can see there's no ref in parentheses. So this is where the tribunal is endorsing as a matter of fact that the CMA is correct to describe hydrocortisone in those terms. And then please can we go to page 417. This is where we see again the tribunal addressing head-on hydrocortisone. Now, before we go any further, I will absolutely acknowledge this is in the part of the judgment dealing with market definition. But nonetheless, you have to read the judgment as a whole, and the tribunal's findings and conclusions have to sort of be read in that light. And it's important to see what is said in this paragraph, because it refers back to the paragraph 44 that we've just seen.
Yeah.
And then it goes on to say, essentially, two particular things. First, the mechanism of delivery is a substantial point of differentiation. I myself would suggest that an EpiPen stabbing you as opposed to a tablet that you take is fundamentally different. But put my views to one side, what the tribunal says is what matters. And you can see what it goes on to say, which is there would be a marked reluctance, they find, on the part of the hypothetical consumer to move from the tablet to the injectable form of hydrocortisone. And that then underpins their conclusion that these are not substitutes.
Yeah.
And so my submission is, well, the tribunal looked at product characteristics, and the tribunal found here that they are not comparable in the eyes of the patient to hydrocortisone tablets.
For the purpose of product market, I mean, as we found in phenitone 1 and 2, you can have products which are not necessarily clinically substitutable, which nonetheless bear similarities or features which provide information. I mean, there was a lot of analysis of AEDs, wasn't there, which were not clinically bioequivalent, but nonetheless, the question was, were there sufficient degree of similarity to enable them to be informative in some way? And
yes.
You found not, and that was on the facts, but this, do you say this is dispositive or just simply an indication that it's not a good comparator?
My Lord, I would not say it is dispositive, because I agree with my Lord that when it comes to comparators, one is not using perfection as the touchstone. One has to, of course, look for, as my Lord observes, a sort of sufficient degree of similarity. So the submission I would make is that here the similarity is very limited. Injections are used in exceptional circumstances. Injections are used for arthritis primarily, and not used in the long term for adrenal insufficiency.
Well, the earlier passage you showed us says, sorry, the passage from the CMA decision says that hydrocortisone has not been used for adrenal insufficiency. It's used for other purposes.
Primarily, that's right, my Lord. I think in very, very exceptional cases, if a patient, yes, couldn't take, for example, a tablet for whatever reason, then perhaps it would be used. I do accept that the tribunal does not name-check hydrocortisone in paragraph 348 when it is dealing with comparables. And that's why my submission is essentially twofold. You read the judgment as a whole in light of the passages I've just shown you, and insofar as the tribunal didn't address head-on the point, of course, the CMA in its decision did provide adequate reasons and fairly evaluate hydrocortisone. And that's why one needs to sort of bear that in mind when dealing with that particular comparator. And that's the subject of our...
Does the tribunal anywhere refer to and therefore endorse on the formulation it uses that part of the CMA decision where it says overall the comparators are based on workable effective competition that we know about at the end of the Matterhorn far outweigh these other 2 or 3 comparators that are relied upon?
My Lord, if we go to page 463, I mean, that is the sum of the tribunal's reasoning on this point. It doesn't specifically, 348, paragraph 348, down the page, please. Yes, there. And so you'll see that, first of all, in 348, it's talking about a number of products, and then it gives Plenadrin as a notable example. And then it goes on to make the finding, which is indeed consistent with footnote 1842, that the price of those medicinal products are not competitive prices, that they are distorted. But the other point I would make is that even though hydrocortisone is not specifically discussed here, the tribunal does go on then to make the point I made already, which is on the comparators, the very best, closest, most meaningful comparator is, of course, the temporal comparator for hydrocortisone tablets. But, my lord, that's as far as I can take it. We obviously have a respondent's notice point, paragraph 6G2, which specifically relies upon the additional reasons the CMA gave in its decision.
And they go on to say in 348, reasons we've given that then prices of medicinal products in the market are not competitive prices, distorted the reasons we've given. And I mean, that's obviously covers plenary.
It does, my lord.
And
my
specifically deal with the pricing of hydrocortisone. But
yes,
the CMA did in the passage you showed.
Precisely right, my
It's
lord.
only produced by one producer, so it's effectively a monopoly product in a very, very niche market.
Indeed, with no competition at all.
No competition at all.
If you rank comparators and you have one which is precisely the same product at different points in time, that may be your alpha comparator. You then have products which are very similar, and then you've got a sort of a decreasing level of relevance depending upon product characteristics, but the same product in the same market. I mean, that was the point in liotharonine. It was the same product in the same market at different points in time.
Indeed.
That was the appellant's point. And there is some force in that. In the same product, for example, in foreign comparator markets, if there's a similar regulatory regime, it's the same product.
Indeed. Well, I would gratefully adopt that sort of way of thinking about that. There may be a hierarchy of the very best comparators, which have the hallmarks of identical product, workably effective competitive conditions, and therefore can tell you something about what the price would be in effective competition. There may be then some other comparators which would be given less weight, maybe less probative, but one doesn't necessarily discard them, but one then looks, and as you move further and further away, in my submission, hydrocortisone is quite far away, not least because it's not really used for this condition. And as my Lord Justice Flaux observes, it's not subject to any competition at all either. So those are my submissions in relation to the two comparators. I'm going to move on to the end of abuse following entry, which corresponds to Auden's ground 1C and Allergan's ground 1C. And in a nutshell, what the appellants say is that independent entry was on the horizon at around the end of May 2015, Auden having, of course, bought off the competition up until then, and there was an expectation of competitive pressure, so they say, that would bring Auden's prices down to competitive levels.
The trigger seems to be the word soon.
Well, my lord, I'm going to say the argument is wrong for three reasons.
But that seems to be the argument.
Yes.
You can identify the point at which new entry is soon.
Yes.
Then that's the point at which you identify a critical difference in analysis.
Yes. And my submission is going to be that, like in liotharonine, these prices were highly contaminated in 2015, and that, as we saw, it took time to unwind the highly inflated prices. The 3 points I was going to make was that first, my submission, the tribunal doesn't make the error of law that's alleged. So it does direct itself correctly to the possibility that a market can self-correct temporarily high prices. And I'll just give you the references. It's paragraph 3232 on page 452 of the bundle, and paragraph 3272, Roman numeral 3, on page 455 of the core bundle. And so, in that sense, there's no doubt in my submission that the tribunal knew about how to approach the law correctly. But that leads on to my Lord Justice Green's point. Secondly, here, Auden's ASPs were at extremely high levels by the end of May 2015. And in my submission, they were manifestly contaminated because, of course, Auden itself had successfully exercised compulsive market power for at least 7 years. And so, indeed, the point made by this court in liotharonine, and I'll just briefly show you that if I may. It's in Authorities, tab 61, page 2036, paragraph 82. Paragraph 82, thank you. And it's about halfway down. The court says this: the emergence of the first green shoots of competition, well, hello, that's around mid-2015, is not therefore an indication that the market is at that point necessarily normal or sufficiently effective or workable. That market might, but will not necessarily, arrive at a mature, workably competitive state at some point in the future. And in this context, the test of contamination has to be correct. In my submission, the court's observation applies in spades here. Even if the owners of the Auden hydrocortisone business had expected entry to occur, because the prices were so high, it's clear that independent entry on the 20 milligram in July 2015, that's when Waymade entered with the full label product, for the 10 milligram when Alyssa entered in October 2015, they wouldn't instantly make prices competitive. It was bound to take time for the market forces to unwind the extremely inflated prices. And can I just show the court some figures to back that up, to take from the abstract to the concrete? We look, please, in the decision, page 1042 of the bundle, paragraph 4.264. Could I ask the court to read that to itself, please? Core bundle, my lord, tab 23, page 1042. And it's paragraph 4.264.
Can you go to the page?
So my lords will have the point that these post-entry prices that you're seeing here, the ones in 2016 and 2018, still within the infringement period, are still way above any of the competitive benchmarks my learned friend Mr. Holmes King's Counsel showed you in table 5.3 of the decision. But there is a further point that I need to address, and it's an important one, which is in its skeleton argument, Allergan, paragraph 45, it's core tab 6, page 118, made the following contention. It said that Allergan correctly anticipated market entry and imminent price reductions. That is wrong. Far from the prices going down around the time of expected entry, Auden's prices went up. And we can see that upward price trend if we look, please, in figure 5.1 in the decision. That's at page 1073, please. And this really is making my Lord Justice Flaux's point earlier this morning. We can see
it from this.
Yes, indeed, my lord. Yes. There were various diagrams all showing mountains of various kinds.
That shows it very starkly, doesn't it? Between May 2015 and about the middle of 2016, October 2015, the price has gone up from something like 55.
Indeed, my lord, £54.
72.
Exactly right, mate. £54.99 per pack to £72.14 in March of 2016. And indeed, there's a similar diagram that the tribunal itself had in Annex 4C to the judgment. So this is not just a CMA decision point. The tribunal itself also annexes various Matterhorns as well. So the court may be wondering, well, why were prices going up and up and up? The only way is up, as the 1980s pop song. The answer is that entry actually occurred later than Allergan had expected. And there is a contemporaneous document that shows what happened. We can go, please, in the decision to page 1529. This is in paragraph 9.157 of the decision. And this is a contemporaneous document of Allergan. And you'll see it's a budget presentation in October 2015. So this is about 5 months after the appellants contend that the market apparently is going to be workably competitive. And what we see in the quote at the bottom on one of the slides is that the product margin is a cool $42.7 million ahead of Allergan's deal model, driven by delayed competition on hydrocortisone. And so, yes, it's right that they were expecting entry, and yes, it's right they were expecting the share loss that they say there, the 60%, but actually, it didn't turn out to be correct. And so instead, this was indeed proved to be not just a near-term cash cow, but continued to provide sky-high returns. And the tribunal reaches the same overall conclusion as the CMA in paragraph 342, paragraph 4, that's core tab 16, page 462, where it finds the prices remain significantly above cost plus and abusive throughout each of the 5 phases that it had identified. And so my submission is that really the abuses did not come to an end at the end of 2015.
What would Allergan have had to do to stop the abuse? So it comes in and sees this position. We've got access. It knows it's got prices higher than competitive level because it anticipates in 3 years' time it'll reach the same level. So what should it do?
So it has a special responsibility not to exploit that position. And I'm going to come on to address, my lord, in relation to intention and the various facts. It knows its costs, knows its returns, its capital, knows its prices, knows the profit margins it's currently earning, and it knows the marketplace. And so, my lord, in a sense, it should take advice from its various advisors and work out what it thinks a workably competitive price ought to be. And as my Lord Justice Green observed this morning, that does not mean, and I want to make that absolutely clear, does not mean a cost plus straitjacket. Absolutely not. So it does not need to buy the business and then suddenly start charging at cost. Because there are various markets where you can have prices well above cost plus, and as my lord, your lordships observed in Phenatone 2, Le Passerelle is a great example of that, where the prices were way above in the bundles market cost, but they were workably competitive ones.
65 to 70%, I think.
Indeed, my lord. And so,
over cost plus.
So that's what should have happened. There should have been a genuine reappraisal of the price setting. But in fact, there was no reappraisal. In fact, it was just, let's just carry on as we have been doing and see how much money we can make, which is exactly what then turns out. So that is my submission in relation to how Allergan could have brought this to an end, and should have brought this to an end. Well, also, I'm going to move...
One way of looking, if you had imposed price regulation upon them,
yes,
by way of remedy,
yes,
the mechanism you would have used would have been probably with a margin for error and generosity and a buffer built into it to impose a fixed price above which the price could not go.
That's
you probably wouldn't do that, but if that's what a regulator is doing, and you were remedying by direction, that's what you would have to do.
Yes, you'd have to draw the line. I think the tribunal in the Albion water damages claim said drawing the line could be a fiendishly difficult thing for anyone to do.
But you may do it with such a margin that you couldn't go wrong.
Yes.
Say 20 quid.
Yes, indeed, which was the enforcement price in this case. Yes.
Yes, I'm not suggesting that the CMA should regularly embark upon price regulation.
No, and the CMA is not wanting to be a price regulator either. It's a competition authority. I'm reminded that in table 5.3 of the decision, the price apparently that Allergan projected would prevail after entry was £5.20. So that's what it was projecting, and the prices were way north of that price. My lords, can I just give you the roadmap? I see I have 5 minutes before lunch. I'm going to turn to penalties. I'm going to say that so far as the statutory framework, the penalty guidance, and this court's role is concerned in penalties, the judgment in litharanine, paragraphs 205 to 211, 232 to 233.
Take that as read.
Take that as read. I'm very grateful. And what I'm going to do is address the issues in a thematic order as follows. First, the concept of undertaking, how its role in penalties. Second, the concept of intention. My Lord Justice Green's question about what it means, why the CMA and the tribunal were right to find these as intentional infringements. Third, the tribunal's approach to penalties in this case. Fourthly, the issue raised by my Lord Justice Green as to how one moves from the undertaking as the addressees of the competition rules to the corporate legal entities as the addressees of the decision. Fifthly, to explain why the penalties imposed on Allergan and then Intas were necessary and appropriate. And sixthly, to deal with quite a few penalty-related arguments raised by Auden and Accord UK, including, of course, its objection to 4 fines for 4 infringements. My Lords, I can start the undertaking issue, if that would be of assistance. It's
We're
about
going to be
a
quite
page.
tight on time. We'll give people. I think we've got a bit of a margin for error at the end of the day.
Yes, my Lord. Yeah.
Or 10 to 2. 10 to 2. Yeah. Break now and 10 to 2.
Very grateful, my Lord.
And we'll.
I'm going to do my level best to try and meet the deadline my learned friend set. Obviously, we'd originally been agreed with the other side 7.5 hours. We're going to have probably an hour less than that at this rate. But I will do my level best to get through the material so that they have time for their
not crying
replies.
for you.
So you need another hour and a bit, hour and a half? Or?
Yes, I would certainly need that. Yes, my Lord.
Okay, that's good.